Hey y'all, welcome back. You're locked in to Overruled, the podcast that reads the law and our lawmakers with a side of sarcasm and turns it all into tea time. It's me, Jay, and whether you're listening from your cubicle, your car, or you are in the bathroom stall trying to get through your workday, I got you covered. This week's legal docket is piping hot, a little bit messy, and guaranteed to make you say, they really let that happen? So grab your notebook, your mental notebook, because it's time for our first segment, Issues on the Docket. Let's roll. Hit it! All right, guys, welcome. We're going to start with issues on the docket. This is where we break down what's making headlines, what's heating up in the courtrooms, and why you should care, even if your only legal point of reference is the Shade Room, TikTok, Judge Mathis, or Judge Judy. Okay, first up, there's a case that I want to share with you all that's got immigration law, foreign policy, and First Amendment concerns all tangled together. There are already problems in and of itself on their own, but this particular case, prepare. All right, so Mahmoud Khalil, a Palestinian activist and Columbia University student, has officially been ruled deportable by an immigration judge. He is a lawful permanent resident with no criminal history. Okay? But the government argued that his presence is detrimental to U.S. policy. What the fuck does that even mean? The judge based their ruling on a Cold War era section of the Immigration and Nationality Act. Yeah, the 1952 version. It's 2025. It basically gives the Secretary of State the power to kick someone out. No real explanation needed. If they say that that person is bad for foreign policy relations, that's it. No formal charges, no public evidence, no justification, y'all. And I mean, we should all be a little uncomfortable with the idea that your immigration status could hinge on whether your politics are approved by the State Department. What times we are in right now, folks. My heart goes out to each and every one of you that are a part of the immigrant community. So let's reflect on this. Are we setting a precedent where political dissent, especially from non-citizens, is enough to get you deported? If so, who's next, honestly? From deportation to sacred spaces, we're shifting to our next case. Let's talk about ICE, the church, and a judge who said, no harm, no hearing. All right, so this next case on the docket, a ruling that might make you rethink what the term safe space really means. Now, a federal judge just denied a lawsuit from 27 religious organizations that wanted to block immigration enforcement in places of worship. They were challenging the rollback of an Obama-era policy that discouraged ICE from entering sensitive locations like churches, hospitals, schools, you name it. The judge said the groups didn't have legal standing because they hadn't been directly harmed yet. But, okay, wait. So we have to wait for the damage to happen first in order for someone to claim that they've been harmed. How many of you all have heard that before? Sound off in the comments. So basically, until someone's dragged out in mid-school session, the courts aren't interested. Imagine laying down your burdens at church and getting laid out by ICE at the same damn time.
Yeah, double homicide.
So, what is the legal angle here? It's not about whether the government should be doing this. It's whether the plaintiffs could prove they'd been specifically targeted yet. A technicality, but a very heavy technicality. Now, something we can sit with from this. What does it say when legal protection doesn't extend to the spaces that are supposed to be the most sacred? Almost as importantly, what does it say about the separation of church and state, aka the First Amendment? All right. I came in hot. Let's take a deep breath. Let's shift to the world of campus sports and a tragedy that's raising hard questions about race, hazing, and student safety. Lastly, we're going to talk about a heartbreaking case out of Bucknell University that's forcing the spotlight back onto hazing, sports culture, and the treatment of Black student athletes. Calvin C.J. Dickey Jr. was a freshman football player. He collapsed during his first practice in July of 2024 and later died. His parents are now suing Bucknell, saying the school ignored his pre-existing sickle cell trait and pushed him through an extreme workout as part of a hazing ritual. Now, the lawsuit alleges negligence and an unsafe team culture. It's also raising eyes to show just how thin the line can be between toughening up and straight up abuse, y'all. Let's be clear. Athletics are not the only arena where hazing commonly occurs in college. Sororities, fraternities, special interest groups. Hello.
All right.
These organizations also make waves in the news for hazing and grievous injury to someone that simply wanted to build community. How many of you guys have either heard or experienced that? You are not alone. And look, Black athletes already carry enough of weight in collegiate sports systems. This young man was showing up, doing what he was told, and paid the ultimate price. Somebody has to answer for this. And it should be the university, as well as those individuals involved in this hazing. What should we be thinking about with all of this? Let's wonder, are universities really doing enough to protect their student athletes? Or are they just covering liability and calling it leadership? Where do we, as a community, speak up and speak out on the things that we know still happen to this day? Let's take a quick break, and we'll be back to dive into a case that will resonate with each and every one of you that have ever experienced workplace discrimination. Okay, y'all, gather around the virtual bench. It's time to sound off the bolo alert in a segment we call Precedent Pending, where the law meets real life and the decisions have the potential to truly shake the table. Now, this week, we're diving into a workplace discrimination case that just shifted how Title VII protections work in a big way. Don't worry, I've got you covered on the details you need to know. So let's talk about the case Muldrow versus the City of St. Louis. Muldrow versus City of St. Louis, decided by the U.S. Supreme Court in 2024, is already being called a game changer for workplace discrimination claims. And listen, the ruling may seem subtle on the surface, but beneath it, a major redefinition of what harm really means in Title VII employment cases. So here's the backstory. Sergeant Jatonya Claiborne Muldrow was a decorated Black woman officer with the St. Louis Metropolitan Police Department. For years, she worked in the department's elite intelligence division. That's not your everyday patrol beat, okay? She was doing high-level investigations, working with the FBI, DEA, and had a plainclothes job working a Monday to Friday type of schedule. Think of those detectives you see on your favorite law show. For me, it would be thinking about Law & Order SVU. Then, a new supervisor came in. And like so many of us have experienced, things changed real quick. He transferred her out of intelligence and into a uniformed patrol position. Still sergeant. Okay. Still technically the same pay. But let's be clear, this just wasn't a cute lateral move. Muldrow had to start wearing her uniform again. She was now working weekends. Her duties were dramatically different. Gone were the high-level assignments, FBI partnerships. Instead, she was overseeing patrol officers and doing basic street supervision. If this doesn't concern you, what would? Muldrow said the transfer was based on sex discrimination. And when she sued, the lower court said, well, it's not really discrimination if your title and your pay stay the same.
Excuse me?
What? Insert the hard eye roll here, okay? Now enter the ACLU. The ACLU of Missouri and the Office of Wilmer Hale teamed up and took her case to the highest court in the land. They argued what so many of us know, but the law hasn't always reflected. The bottom line that discrimination isn't just about the size of your paycheck. It's about power, opportunity, and how bias can show up in subtle but career-changing ways. The real legal question at the center of this case falls under Title VII of the Civil Rights Act of 1964 and poses the concern, do employees have to show significant harm, like a demotion or a pay cut, in order to prove discrimination that's based on sex, race, religion, etc.? Lower courts have been split on this. Some circuits required a materially adverse employment. Girl, what the hell does that even mean? Others had a more lenient view. And let's be honest, this significant harm standard was being used as a legal excuse to ignore everyday bias and microaggressions dressed up as neutral HR moves, pivoting, buzzwords like that. The Supreme Court, surprisingly, y'all, said, nah, we don't agree. Now, you may ask why this case matters if you haven't been able to glean from the story up until this point. Now, this ruling is a win for workers. Full stop. The court unanimously held, yes, unanimously, that Title VII doesn't require plaintiffs to show a significant disadvantage, just that the individual experienced some sort of harm in terms of the terms, conditions, or privileges of employment. What does that mean in practice, though? Because I get this could go over many people's heads, okay? It means that employers can't escape accountability just because your paycheck stayed the same. If you were transferred, excluded, reassigned, or sidelined in any way that disadvantaged you because of your gender, race, or religion, that's actionable now, okay? Note that the categories exclude sexual orientation. We'll leave that there. For Black women, in particular, who overwhelmingly experience these subtle but insidious forms of workplace discrimination, this case opens the door for justice that's been long denied. It also sends a message to employers. Lateral doesn't mean harmless, and same pay doesn't mean no problem. So here's my take. Honestly, we know bias doesn't always show up as a pink slip or a pay cut. Sometimes, and I can attest to this from firsthand experience, it's being bumped off of a key project, stuck on a bad shift, or reassigned out of the room where the things actually happen. This isn't just about Sergeant Muldrow. This is about everybody who's been strategically sidelined, reassigned, or shuffled into obscurity because Tad, Karen, or those self-appointed gatekeeping Blacks, which, shout out in the comments if you know what I'm talking about, those people thought that they didn't fit the culture. I know you know what I'm talking about. And how many times have we heard that? You're just better suited for something else. You know, this role needs a different kind of energy. You know, no. It's giving vibes-based discrimination. And for me, that is a huge chop. The reddest of red flags. This case tells us that the law is finally catching up with reality. That harm isn't always financial. Sometimes it's structural. It's about who gets access and who gets left out. And let's not forget or act like Sergeant Muldrow didn't lose out on more than status. That reassignment took her out of a professional pipeline. From FBI cases to patrol supervisor, sis, you don't need to know the law to know that that's some shit. Same badge, but a whole different career trajectory all of a sudden. Wild. So yeah, this ruling might not be flashy, but it's foundational. Title VII just got a little closer to doing what it was always supposed to do. Because of this case, bias has a little less wiggle room. And that, my friend, that is a win for all of us. Let's take a quick break, and we'll be right back with our next segment. Welcome back, everybody. Hope that you have been enjoying this show so far. This is actually the first real episode where we're talking about things in the law, and I'm so excited to be sharing all of this with y'all. I'm sorry, I can't stop saying y'all because I'm from Louisiana, I'm Southern. So I'm actually curious to know if the Southern draw comes out at all in this, but that's neither here nor there, okay? We're transitioning right into our next segment called Cite Me, Don't Fight Me, okay? Let's face it, sometimes people do strange things, and the American people are of no exception. You didn't need me to tell you that. When police across the US are faced with a situation that they've never encountered before, there may not be a legal remedy because no one ever expected anyone to do that thing in the first place. Hence the reason why we have this segment called Cite Me, Don't Fight Me. To deal with some of the more bizarre situations people have encountered, lawmakers of the past created equally weird laws so they wouldn't have to deal with problems like that ever again. Now, while some of this may seem sensible, some of the laws that were created as a result are unhinged in modern times. Now, despite this, many are still in the books, even if they aren't enforced. This week, we'll start by taking it back to my good old home state, Louisiana. This is not how I wanted to bring my home state into the chat. Y'all, with this law, mourners at a wake may not eat more than 3 sandwiches in Louisiana. Fact. In Louisiana, you cannot have more than 3 sandwiches at any wake. Like, legally. Cue the confusion, because what? Apparently, this was a thing in the 20th century. Back in the day, people had to recognize that you can't eat your grief away down to the way. This law aims to maintain respect and moderation during somber gatherings. The fact that this ever became a law is wild. I highly question how often this law was enforced. And at the same time, I want to know when this law was enforced, because the entire thing to me seems increasingly petty. Also, who would be the designated person counting everyone's calories and sandwich intake? So if you thought doing taxes was hard, try being a judge assigned to a case where your homegirl had 4 egg salad sandwiches instead of 3 at the wake. What the hell are we doing here?
The ultimate shade of it all.
Okay, next law. Let me just give you a couple of key words here. Ice cream cones and horse theft. Never thought you'd hear those two in the same sentence, right? Well, this next law is even more bizarre. Did you know that in Alabama and Kentucky, it is, or at least it was, legal to carry an ice cream cone in your back pocket? I just, you know what, whatever. This was not because of dairy regulations. This was not because ice cream is sticky and gets all over the place. No. The law was in place because it was a loophole for horse theft. Again, what the f***? Thieves would apparently sneak up on a horse with a melting cone tucked into their back pocket and just walk away slowly. The horse would follow the scent, and poof, no theft technically occurred. The horse walked away. You didn't grab the reins. The horse just followed you home. Wow. This is an early example of legal gymnastics at its absolute finest. And also, who knew that horses enjoy their frozen dairy treats as well? I sure didn't. Can you imagine that arrest report? Suspect was last seen with 1 scoop of vanilla and the intense lure. What? It's giving dairy-driven crime wave. Dairy-driven what? Popsicle posse. It's giving a lot that makes 0 sense. It's also giving, sir, you are under arrest for unlawful ice cream placement. How dare you put that ice cream in your back pocket? And honestly, if lawmakers had time to draft that kind of mess into law, then I surely have time to rant about my law school anxiety that is creeping up at me left, right, and center. Yeah? Yeah. We'll be right back. All right, folks, everybody, thank you so much for hanging out with me. I'm ready to get into my favorite segment that I feel many people will be able to resonate with. So, yeah, let's talk about it. This segment is called Objection, Your Honor. And here, I kick my shoes off, cozy up in my sweats, and share with you some of the things that I raise a proverbial objection to. Whether it's petty, whether it's serious. Probably both. Let's talk. This week's objection, my comfort zone. Y'all, time is so fleeting right now. I am less than 4 months away from starting law school, and I've gotta say, I am excited, but, and yes, it's a big but, I am paralyzed by the fact that my free time and state of existence will be forever changed. Right now, life is relatively stable, and I work in a really solid job that gives me the latitude to run errands during the day. Run over to Trader Joe's, get the fruit, get whatever I need to, sometimes. And also, every now and then, dip on over to my favorite coffee shop while I send a few work emails. I could do my workouts whenever I wanted, basically, and could jump on a work call whenever it was necessary from home. Now, don't come for me, y'all. I worked my ass off for this, okay? To be clear. This is where my petty objection comes into play. This version of a soft life, as I know it, will be flipped on its head, including a full-time law school workload at the end of my workday. The dean has already level set the incoming class to prepare for 20 to 30 hours of study each week. Did I know this up front? Well, yes. Did I also do all of the work to get a seat at the table and experience this self-imposed rigor? Yes. Do I have the right to complain? Yes. Like, how, Sway? How? How is one supposed to be able to juggle a minimum 40-hour work week in tech and then say, let me jazz this right on up with 30 hours of reading, writing, and listening to lectures? My personal life will be the thing that's on an extended leave of absence, not me. But I do recognize that these next 3 years are a temporary state, and the other side of this will yield something I've always wanted that is bigger than I could have ever imagined, really. Although I'm a little overwhelmed just in talking about this with y'all right now, I am so incredibly excited and honored that I've been afforded this opportunity and recognize that the level of focus, discipline, willpower required here has to be nothing short of 5 stars. And that is why I'm taking the next 4 months to have as many fun, enriching life experiences as possible. That includes seeing Kendrick and SZA, seeing Beyonce, and also celebrating my upcoming birthday with that extra sprinkle of bad energy in there. Having these experiences and sharing in some quality time with my friend group is going to be the best way to charge my batteries to enter the Thunderdome that is law school. Although I am objecting to this on the surface level, I have no choice but to overrule it. One thing that I know for sure is that I have what it takes to do this. Child, I've experienced much, much worse with even less of a reward, if any at all. Let's get this work. All right, y'all, that's a wrap on this episode of Overruled. We've gone from the courtroom to the campus to the heart of the immigration system. And if there's one thing we know for sure, it's that the law just isn't some abstract system, nor is it one size fits all. It's personal, it's political, it's convoluted. And it shows up in people's lives every single day, whether you understand the law or not. Now, whether you're chasing a law degree or any degree, watching the news with a bit of dread and exhaustion, or just trying to stay awake through your workday, baby, this space is for you. If something today made you think, made you mad, or made you want to tap into our good sis Google, excellent. That is the point. Do me a favor. Follow the show. Leave a review, a good one, and hit that 5-star button whenever you're listening. Whenever and wherever, actually. It helps more than you know. And it's how we start reaching the folks who really need to hear about these stories and partake in these conversations. Can't do it alone. Share this show with your friends and family. Let's build community. I'm so interested to see what communities gravitate towards this show. And listen, this show isn't just about me taking things on and talking into the void. I want to hear from you. Got a legal hot take, a rant for objection, Your Honor, or a weird law you know of that you want to feature in Cite Me, Don't Fight Me? Slide into the DMs or hit the link in the show notes to submit your stories, questions, or rants. Let's make this a two-way convo. I don't like talking to myself, at least on camera, like this. Follow us on Instagram, Blue Sky, and TikTok at Overruled Podcast, and on YouTube at The Overruled Podcast. Got something you want to share, suggest, cite? Hit us up at theoverruledpodcast@gmail.com. We read everything. And yes, we talk back. So talk to us nice, okay? As always, don't forget to overrule your doubts with your ambition, the facts, and the receipts. I'll see you guys next time.